Thank you all for joining us today. So to start off, we're going to share a little bit about our organization. So we are Alliance San Diego, and we are a community organization whose mission is to build collective power so that we can create an inclusive democracy. By working together to engage effectively in the civic process, we can make systemic change and shape the future that belongs to all of us. And together we can create a more inclusive democracy where all people can achieve their full potential in an environment of harmony, justice, safety, and equality. And now to share a little bit about our Human Rights Department, our team consists of our immigration attorney, Michelle Soleri, who is going to be presenting today, our Department of Justice fully accredited representative, Hector Oviedo, and myself, Andrea Tecpoyotl Tepale, and I am an upcoming Department of Justice accredited representative. And some of the legal services we provide in-house include consultations, naturalization application, DACA renewals, green card renewals, TPS, and more. And we also have our education and outreach program where we provide events and presentations around topics such as citizenship, know your rights presentations, public charge, and more.
Hello, everyone. Welcome and thank you for joining us tonight. My name is Michelle Soleri, as Andreas mentioned, and I just wanted to go over what we're going to be talking about tonight. So what you can expect today is we're going to go over the public charge rules. There's been a lot of changes. You know, there was the old public charge rule, the Trump rule, the new rule. And so just giving you a little bit of clarity of where we are today and what that looks like. We're going to talk a little bit about Medi-Cal for immigrants and who qualifies for that. And we're also going to talk about immigration remedies. So, and what you can do to prepare for consultation and what remedies might be available to you. So let's get started. So, as some of you may have heard, there was a public charge rule that took effect starting in December of last year, so 2 months ago. And now it's been in effect for roughly 2 months. So we want to talk about what that looks like and what you can expect from the new rule. So first of all, before we talk too much about it, I want to just say that this new rule provides a lot of clarity and a lot of information about what is public charge and what's not public charge. So we're going to start with the definition. So a public charge is an individual who is likely to become primarily dependent on the government for sustenance. And what that really means is they're going to receive cash assistance for income maintenance and long-term institutionalized care at government's expense. And we're going to go over what each of those things mean in depth. But when you're looking at public charge, you really want to think of it as a funnel. So you want to go through the 4 different steps. So the first step is when do they even consider public charge? When is that determination even made? Does it always apply to people? When does it happen? And then if it is made, if there is going to be a public charge determination, are you one of the people that qualifies for an exemption from that determination? And we'll go through all the different exemptions. And then if you say you don't qualify for an exemption, what benefits can affect your application? And if you take advantage of benefits that affect your application, what other factors are considered? And so we'll go through each of those different steps, and then it should help clarify what's really gonna impact you and when. So to start off with, when is the public charge determination actually taking place? So there's very few scenarios where they actually make this determination. So one is when somebody applies for a non-immigrant visa. So what that means is you're applying to come to the United States for a particular reason, whether it's to come as a tourist, apply for a student visa, maybe come here on an employment visa. And if you're coming for those reasons, they want to make sure that you're going to be able to support yourself while you're in the United States and not when you come here. So that's one thing. The other time is if you are applying to become a lawful permanent resident, and that's the majority of determinations are made is when you're applying to become a lawful permanent resident, but there's so many exceptions. So we'll talk about those exceptions. And then lastly, A green card holder is somebody that's already a lawful permanent resident who leaves the United States for more than 6 months at a time and then comes back in. And the reason why there's an exception for green card holders at this particular time is because when you leave for 6 months, there's a presumption or they assume that you're abandoning your green card. And so when you come back, they're gonna make an evaluation as if you were applying for a green card again. And that's why there's that determination after the 6 months abroad. So let's talk about when it's not, when they're not looking at it. So when you apply to become a citizen, they don't look at it. When they don't look at it if you fall under an exemption, or when you, and this part's new. So if you have a visa and you apply to change your status or apply for an extension of status, they're no longer looking at that. So say you are here on a tourist visa and you're changing your status to a student visa, they're not going to go back and say, hey, is this person going to take advantage of public benefits? Are they going to become primarily reliant on the government for sustenance? They're not going to look at it anymore. It's only when you're abroad applying to come into the country on a visa or when you're applying to become a lawful permanent resident. So let's talk about those that are applying to become, so it doesn't apply for those that are applying to become lawful, it doesn't apply to lawful permanent residents unless they're coming back after 6 months abroad, like I mentioned, but it also doesn't apply to refugees and asylees. It doesn't apply for VAWA self-petitioners, and VAWA is those that obtain their green card through domestic violence. It doesn't apply to those other types of survivors of domestic violence, those that get their green card for as a U visa holder, which are victims of a crime, nor to T visa holders. And T visa holders are those that have been victims of human trafficking. It also doesn't apply for special immigrant juvenile status. So those that get their status because they have been abandoned, abused, or neglected. And that's how they obtain their green card. It doesn't apply to them. And then it also doesn't apply to DACA, TPS, or certain parolees. And so I put the little asterisk there, and you'll see that because while it doesn't apply when you apply for DACA, it also doesn't apply when you apply for TPS or the other parole options. At the juncture that you apply for a green card, they can look at that status, but it doesn't apply for when you're in that status. You're applying for those different statuses. It's just at the point when you go to apply for your green card, even after having that status. And so, you know, this part was really confusing when we started seeing a lot of people coming in from Ukraine and Afghanistan, and the government started opening up all these refugee resettlement benefits, but they weren't refugees under the law. They were called refugees, but it was a technicality that they weren't. And they were being offered all these refugee services. And so one of the concerns we had as attorneys and practitioners is that were they going to hold these services against individuals that took advantage of them when they were told that they could? And so the services that they obtained during that time won't be considered against them for public charge, but that parole is valid generally for 2 years. And once that 2 years is up, once the 2 years of being able to take advantage of the refugee resettlement services is up, then they can start looking at those things. So during that limited time period, it's not considered, and then afterwards it could be. So now we know who is being looked at. We know it's those that are applying for green cards and only some people applying for green cards. Now, if you're one of the people that applies to, let's look at what is actually considered. So they consider federal, state, local, and tribal cash assistance. So those are a supplemental security income, temporary stat assistance for needy families, and any other state or local cash assistance program. So that's if you're getting money on a continuous basis. So say you find yourself in a financial need and an organization gives you a grant of $500 or $1,000 one time cash assistance is not continuous assistance. It's not to maintain your income or maintain your life for a continuous period of time. It's one time. So they're really only looking at continuous financial assistance. And then the second one is long-term institutionalized care at government's expense. And we're going to go a little bit more into depth about what that means in a second. But I did want to show you, like, this rule is super clear and it explicitly states in the application which programs they're looking at. So you don't have to trust me. It's right there in the application. So it says it looks at Social Security income, temporary assistance for needy families, or state, tribal, territorial, local cash benefits assistance program called general assistance, and long-term institutionalized care at a government expense. Those are the programs that they look at. It's yes or no. While there are other factors and other questions that are asked, those are secondary to these two primary concerns. So if that's all they look at, these are all the programs they don't look at. They don't look at CHIP, the Children's Health Insurance Program, Supplemental Nutrition Assistance Program, WIC, housing benefits, immunizations. So anybody that got COVID vaccines or flu vaccines or anything that they need, that won't be considered. It doesn't include California State Funded Nutrition Assistance Program, Medicaid for anything other than long-term institutionalized care, or tax credits. So if you took advantage of the California tax credit, or if you took advantage of the credits that were giving out, the stimulus checks, those were considered tax credits. That wouldn't affect you at any point in time. And so a lot of people were concerned, okay, I'm not going to take advantage of public benefits. I know that I'm worried about doing it, but the government only looks at you. So if your child takes advantage of any program, they're not looking at your kids. It's specific to the applicant and it's not about their family members. So if your kids qualify for something or your spouse qualifies for something, they shouldn't hesitate in taking advantage of the benefits they qualify for. So I want to take a deeper dive into medical care and kind of differentiate what we're talking about with the long-term institutionalized care. So in the state of California, we have Medi-Cal, and everybody qualifies for Medi-Cal at some level if they meet the financial requirements. So everybody can get emergency Medi-Cal, which is in case of emergency, you have an accident, you break an arm, you can go to the emergency room. But emergencies also include prenatal care, the birth of your baby, 60 days after the birth of your baby. So postnatal care for that short period of time. And everybody qualifies for that. But we're so lucky to live in the state of California because we've expanded full coverage Medi-Cal for those that are 25 years old and younger, and those that are 50 and older. So that means that they can go to a primary care physician, they can go see a dentist, they can go see an optometrist for their vision. And so they can take care of all those things right now in California. And fortunately, we're pushing to extend it for everybody that's undocumented, and we're looking to see that go into effect in the next couple of years. But right now, this is who qualifies for full coverage Medi-Cal. And all of these things, none of this counts towards public charge. So let's talk about what constitutes public charge. So that's long-term institutionalized care at government's expense. So that's like nursing facilities, mental health institutions where people are there for extended periods of time. We've had plenty of clients that have suffered from depression and they've ended up in the mental institution for a week. And that's never been an issue. So it's not about short stints, it's about the long-term care. And so it definitely does not care, like I said, things that are for a rehabilitative purpose. It's not going to include those short little stays, and it's definitely not imprisonment. So if you've been detained, it's not going to include that. You don't have any control over over that. So that is not considered in your long-term institutionalized care. And so say you have taken advantage of some public benefits and the public charge applies for you, th- that doesn't mean you are considered public charge. If you took advantage of it, then they come to these secondary determinations or secondary factors to determine whether or not you're going to be a public charge. So they look at your age. Are you somebody that's going to be able to work for an extended period of time? Or are you elderly? Are you healthy? What is your family status? Do you have family members that you live with that help take care of you? What does your assets look like? What is your education? Do you have a higher degree of education? Um, and then also affidavits of support will be favorably considered. So this is a very important factor. Affidavits of support state that an individual will be financially responsible for you, and they have to make a certain income in order to be your sponsor. So those things are favorably considered, and it's a contract with the government saying that you won't take advantage of programs, or you're not you're you're not likely to become a public charge, and if something comes up, that they would be financially responsible. And then they also look at, have you ever received public benefits in the past? How much? How long were you on them? And just because you've been on public assistance in the past is not enough to exclude you. And so that's really important to know, like if you take advantage of it at a time that you really need it, because everybody goes through something in their life where they need a helping hand, and whether that's from family or the government, that's not enough to hold it against you for the rest of your life, right? And so the government really takes a look at that, um, and it just uses it as a factor, but you can see there's lots of other factors there, and the affidavit of support is strongly weighted in this determination. So, okay, so now say all of that went and happened. So they determine the public charge rule applies to you. They determine that you took advantage of the public benefits. And then they said that you can't overcome a public charge determination. You are likely to become a public charge. What do you do then? Well, in the event that that happens, you can overcome that with a bond. So they can ask for you to pay a bond to show that you won't be a public charge in the future. And then if you become, if you permanently leave the United States, or you die, the bond unfortunately die, the bond will be canceled. Or the applicant can also request the cancellation of the public charge bond by filing a form after 5 years as a lawful permanent resident. And if you think about it, it makes sense, right? Because if you become a U.S. citizen, it gets canceled. Your bond is returned to you. And at the 5-year marker, you qualify to become a U.S. citizen. So it makes sense that the 5-year marker is the time frame that they would allow you to apply for it. So these are a lot of questions that I get, or some of the questions that I get. So I want to go over some of these different scenarios. So the first person says, a couple months ago, I obtained asylum. I am now worried about taking advantage of TAMP because it will hinder my ability to obtain a green card. So if you remember from one of our first slides, it says that the public charge rule does not apply to asylees. So if you qualify for the benefit, you need the benefit, definitely take advantage of it, and it's not going to affect your application if you are an asylee. The second person says, I'm pregnant and I need help, and I'm currently enrolled in Medicaid. Medicaid is Medi-Cal. Medicaid's the federal name for it, but I'm worried that this will be used against me. And remember that public charge determinations are not for emergency circumstances, and that is written in federal law. And so you will be protected from that determination. So remember that if you're pregnant, you can go, you can be at the hospital, they can help with all the prenatal, the birth, and then help you with all the postnatal care afterwards. And your baby, take care of your baby, because the first year of life is so important to have the regular checkups with the doctor. And lastly, my friend says that the public charge will be used against her, so she canceled her SNAP, and she says I should do the same. So this part is really a little bit tricky, because when Trump was in office, he changed the public charge rule, and he said that enrolling in SNAP was part of the public charge evaluation, and it could be held against you. But this new rule changes all of that. And so you might be thinking, well, if Trump changed it to use it against me, how do I know that none of these programs that the Biden administration says won't count against me won't ever count against me? So the reason why you know that is that the Trump administration just came out and changed a policy. He said, I want to use these programs against people in this public charge determination. The Biden administration changed the rules. They wrote it out. They went through the whole regulatory process, which means that they wrote it down and they allowed all the community members to submit comments to it, congressional members to submit comments to it, and make edits to it. They evaluated all of it, and they went through, I think it was a nearly 6-month process to make it a regulation. So in order to change it, there's a lot of things that have to happen to get that going. And so if there were a change, it wouldn't be changed overnight. And also, if there were a change, they can't look backwards. They can't say that you took advantage of something when it was okay, and now I'm going to hold it against you because now I say it's not. So these types of laws aren't looked at retroactively. They're always looked at from the time that we change it and forward. So we went through a lot of the different types of public charge things, but I want to talk to you about how can you actually apply for a green card. So there's lots of different ways to apply for it. So I want to go through some of the remedies, some of the ways that you can do that, just briefly to give you an overview. So some of the forms of relief are applying for a green card through family or employment. So through family, you're looking at your spouse, generally your spouse, your parent, or your children who are over the age of 21, who are U.S. citizens and or lawful permanent residents. In some circumstances, you can apply for siblings, but that's going to be a longer wait list. They're going to be put on a wait list for that one. Or you can apply through employment. The tricky part about employment is that you have to always maintain lawful status in order to qualify for employment. And so say you come here on a tourist visa and now you want to apply for a green card through employment, but you overstayed your visa for an extended period of time, well, then you would qualify to apply for a green card through employment. And definitely not within the United States, and maybe abroad, but it depends on the length of time that you are in the United States without authorization. And then there's lots of visas for victims of crime. So the U visa, I touched on it briefly. Well, going back to the green cards on number one. So for this group of people, there will be a public charge determination for everybody in that category. For this next group of people, there is not going to be a public charge determination. So these are for visas for victims, and these are all of our humanitarian ways to get green cards. And even though it's called a U visa, it's because it starts as a visa and converts to a green card. So the U visa is for victims of certain crimes who cooperate with law enforcement. And the idea is that we want individuals, regardless of their immigration status, to cooperate with law enforcement when their crimes are happening. We don't want, you know, people to be able to commit crimes against individuals and get away with it because somebody's afraid to come forward. And so those that have the courage to talk to law enforcement after it happens, um, to detain and charge people that committed these crimes is something that we that the government has decided to protect and give a benefit for. And then the VAWA is for victims of domestic violence, where the person that committed domestic violence against them was their U.S. citizen or lawful permanent resident spouse, parent, or child. And the reason why this is a way to get a green card is because any of these people could have applied for them to get a green card, but instead of doing that, they're using many times they use somebody's status as undocumented to further abuse them or manipulate them. And so the government decided that they were going to give a way to obtain a green card for individuals in this circumstance so they're not continuously being victimized or harmed by their partners or child or parents even. And then the T visa is for victims of human trafficking. And, if you report it to law enforcement and you go through the same process, you can also get a green card that way. And, victims of human trafficking, lots of people consider it like, sex trafficking, but lots of times it's also employment. Like your employer brings you into the United States, they take away your passport, and now you have no way to get around. Maybe you don't have the ability to leave your workplace. And so we see all different sorts of scenarios come up, the TV says. Um, the special immigrant juvenile status is minors who are abandoned, abused, or neglected. They also don't have to undergo the public charge determination, and they can apply for a green card. So where you might see this is anybody that ends up in foster care, or maybe their parents are deceased, or and they have nobody to take care of them other than like an aunt or uncle or family member or friend. Um, or anybody that has been considered a ward of the state. Those are individuals that can apply for a green card. There's a bit of a process to it, but I always like to talk about this one because it takes adults to look at this and see it and recognize it to help our minors and our youth get the type of assistance that they need. Um, and lastly, there is ways to obtain a green card in removal proceedings that are outside. All these things can be obtained in removal proceedings, but there's also some other minor areas of relief. And so I always want to make sure that people know that sometimes you can fight your case in court and get a green card that way. Um, and I'm gonna go go through a little bit of that, but um, you know, when you are thinking about, you want to apply for a green card, you want to know what your resources are, like what your options are. You definitely want to go talk to an attorney or a Department of Justice accredited a representative, like Hector on our team, and Andre is almost there, so that so that you get the most important information. So you don't want to just show up to your meeting. You want to show up to your meeting prepared, because you're only gonna get as good of advice as the information we're provided. And so the things that we're going to ask you about are your entries in the United States. When did you last enter the United States? How many times have you come in and left? Did you come in with a visa? Were you apprehended at the border? Were you fingerprinted? Past petitions. Has anybody ever applied for you before, or any of your other family members before? Sometimes, somebody in your family could have been petitioned and you could have been a derivative of an application and not have even known it. And we saw that recently, and we were able to get somebody, or we're in the process of getting somebody a green card that based on a petition that was filed for her mother in 2000. So we're talking 23 years ago. And so that's something that can happen. You want to be able to share your immigration court history. Have you ever been in proceedings? What happened? Did the judge order you removed? Did they administratively close your case? Was it sent to the Board of Immigration Appeals? Uh, what happened? And do you have a copy of any of your documents? Uh, what is your A number? Your A number is your file number, and you only have an A number if you are picked up by immigration, and that's placed in removal proceedings, or you've applied for an immigration benefit. And so, like, if you have a work authorization card, you will have your A number on there. They call it the USCIS number if it's done through an affirmative process. You also want to have all the information about contact with immigration officials, with the police, criminal history, and employment and address history can be important for some types of applications as well. And generally, we're only talking about the last 5 years. And so when you go to your consultation, there's a couple of things that you want to leave your consultation knowing. So the first one is, do you have a remedy available to you now? Is there, and then if you do, what is the process moving forward with your cases? Do you need to gather documents? Do you need to get a Freedom of Information Act requests to get documents that you can't obtain on your own? Or is there nothing available to you right now affirmatively? Can you not apply for something before USCIS? And if that's the case, if you were to be picked up by immigration, do you have a remedy available to you in court? Because if you were detained by immigration, you want to know what your options are. Lots of times people are pressured to sign their voluntary departure and return to their home country, and they don't know that they could obtain a green card in court, or they could extend their stay here. And you just want to make sure that you know all the options available to you at that point in time, so that when, ahead of time. So if you ever end up in a bad situation, you know what your options are going to be. And then lastly, we talked about meeting with an immigration attorney or the Department of Justice accredited representative. You want to make sure that whoever you're talking to is familiar with immigration, that they're licensed to give it legal advice, because there's a lot of people out there that give information, and it's not necessarily bad people. It's, a friend that wants to help you fill out an application, but they might not know the consequences of filling out an application the wrong way, or um, that you didn't qualify for a benefit and then they filled it out, and now you have issues with immigration. So you definitely want to work with somebody that knows what they're doing and check and make sure that they do. So if you go to calbar.ca.gov, you can check and see if somebody is licensed in the state of California. And then I mentioned that you can work with a Department of Justice accredited representative. You can check it out and see if they are licensed to practice as a DOJ rep. And the beauty of a Department of Justice accredited representative is that they go through a training. They might not be an attorney, but they are affiliated with an organization that's already recognized by the Department of Justice. They've gone through a lot of training. They have an organization that backs them up. If there's anything that happens in your case, anything that goes wrong, there is recourse for you. You have the ability, to sue somebody for malpractice. You don't have the ability to sue the notario for because they didn't give you proper legal advice. And for attorneys, you can look and see if there's any past disciplinary actions. You can go on the website and look up their name and see if anybody, if there's been complaints filed against them, and what the result was. You also want to look and see what their area of expertise is. Immigration is so complicated. I mean, just in this webinar alone, I talked to you about the first public charge rule, the Trump public charge rule, the new public charge rule. That's 3 public charge rules in a matter of 3 years. And so on just one very small area of an adjustment application. So you really want to make sure that whoever you're talking to has experience in immigration law, and that's the primary focus of what they do because it's ever changing and you want to make sure that they're knowledgeable. And then you definitely want to get a written contract. So that's your way of showing that, yes, this person represents me. And these are the terms. This is what they're going to provide. This is what I have to do. And that way there's a clear understanding of what's happening. And keep copies of everything, absolutely everything, because that's the way to protect yourself. So thank you all so much. We are open to any questions that you might have, but thank you for joining us today. I'll turn it over to Andrea.
Like Michelle said, thank you for joining us today. We will now be taking questions, so you can feel free to type them in the chat, and we will be looking and answering them now. And also, just as a reminder, we provided our phone number here on screen, as you can see, and our email as forms of ways that you can contact us. And again, some of the services that we provide are consultations, naturalization applications, supporting with DACA renewals, green card renewals, TPS, and more. So feel free to reach us via phone or through email. And like I mentioned, if you have any questions, feel free to type them up in the chat.
Andrea, how much do we charge for our services?
$0. We do not charge for our services. Our consultations are free. So feel free to give us a call or email us, and we will get back to you as soon as possible within 1 to 2 business days.
It looks like we have a question that came up in the Q&A. It says, what happens if a resident used public benefits as soon as they became residents, like Medi-Cal or food stamps? So when you fill out your green card application, they ask you if you are likely to become a public charger. If so, they want to know if you were honest in your application, right? So if you were saying that you're not likely to become a charge, you haven't used any of these benefits in the past, then there's nothing to worry about. So the issue that can come up in the future is, or when you apply for citizenship, if you lied on your initial application, that's where it came up. But say you became a lawful permanent resident and then your spouse gets laid off of their job and you go on food stamps. Well, you didn't know that that was going to happen ahead of time. So that's not going to be something that is going to be used against you. It's definitely not going to be used against you for public charge purposes. If you take advantage of food stamps in the very beginning, well, first of all, food stamps is not one of the benefits, so we'll start there. But say you were to take SSI or something like that, that could be used because it's cash assistance, but food stamps is not cash assistance, so that's not part of the public charge determination, and it wouldn't even be used to or looked at in the future. Medi-Cal, if you qualify for it, you qualify for it, and it's not something that is going to be considered a public charge determination. And you're already a lawful permanent resident, so you qualify to use it. It's only if, like I said, if you knew that you were going to take advantage of certain, like these particular, like I said, SSI, what was the other one for finance, for assistant, continuous assistance? I'm blanking on the name of it, but if it's continuous cash assistance, that or long-term institutionalized care. So if you're on Medi-Cal, that doesn't mean that you're going to be in a nursing home for the rest of your life. So those are the things that we're looking at. So if you take advantage of it right away, food stamps, Medi-Cal, you're good to go, no issues. SSI, somebody said is SSI public charge since it's cash aid. So SSI would be considered a benefit that is in the public charge calculation. So if you take advantage of SSI, it is something that they look at, but it just because you took advantage of it doesn't in and of itself mean that you are a public charge. So they say you took advantage of it. They look at all the other factors. They see if given the totality of the circumstances, you will be a public charge. And then even if they decide that you would be, that would be when you could apply for the bond. And then let's see, we have another question. Let's see. Do you have to support your answers on I-485 regarding public benefits with evidence? Some of the questions on the 485 ask how much money your household earns. Do you need evidence? Also, do you submit diplomas, certificates to support your answers on the 485? So everything you write in your application is under penalty of perjury, right? So they might ask for all this. They ask for all this information. It's not something that you have to back up with documents, but you have to remember that everything you say, you're swearing under penalty of perjury, that it's going to be truthful and accurate. And so, you know, that could, if you apply for citizenship down the road, and what you said wasn't honest, well, then that is a misrepresentation in your application. And then that's where the issue would come up. So you wouldn't see it at this stage. You would see it when you went to apply for citizenship, if they ever found out that you lied on the application about it, but you don't have to supply the additional documentation for it. And please, feel free to ask more questions about it if I didn't answer it clearly, or if you have any further questions about it. I know it can be a little bit nuanced in in how it's looked at, especially since we're looking at our funnel, right? We're looking at, do they look at public charge for you? If they look at public charge for you, does the benefit you're using count towards public charge? And if it does count towards public charge, what's the totality of the circumstances? And if they find the totality of circumstances that you will become a public charge, can you get a bond? And so, like, narrowing it down is the most important part of this whole determination. Okay. It looks like we got another question here. If I was awarded Medi-Cal as the partner of my wife, even though I refused it and it got canceled as I was concerned about public charge, this would not negatively impact my naturalization application. Just asking as it proves ties between my wife and I need to submit extra info as part of, okay. So you're, qualifying for Medi-Cal, like, first of all, it's a benefit that you receive. It's not a benefit that your wife received. And even if it was, Medi-Cal is not part of the determination, right? So what you're looking at when you're applying for your wife to get her status, and so as I want to make sure I am answering the question properly. If I was awarded Medi-Cal as a partner of my wife, even though I refused it, got canceled. So at the naturalization stage, they don't look at public charge at all. That's not part of the determination. The only way it could end up as part of the determination is if you made a misrepresentation previously. So you don't, it's not part of that application. But even if you applied for Medi-Cal, like I said, Medi-Cal is not part of the determination. And if it was in the green card phase of the process, the only way that it could affect somebody is, when you're petitioning for somebody, you're trying to prove that you make enough money to support them. And so you just might not meet the income threshold if you qualify for Medi-Cal, but that just depends on, what your income is that qualified you for Medi-Cal. And then it says, can I be a public charge after I become a citizen? Like if I use benefits as a resident and they found out. So you can use all the benefits you want as a resident. There's no issue using benefits once you become a resident. It's a question of, did you lie in your application saying that you weren't in need of any services, and then, but you really knew that you were. And so after you become a citizen, there's no look at your public charge, whether or not you were likely to become a public charge when you're applying to become a resident. So it's not looking backwards like that. After you become a citizen, you became a citizen. So I think maybe to provide a little bit more clarity, when they make a public charge determination, they're determining whether it's likely in the future at some other date and time you are likely to become a public charge. So they look at, past experiences or things that have happened in the past to help make that determination about the future. But what you do in the future does not impact where you were when you applied for lawful permanent residency status. So after you become a citizen, after you become a resident, the things that you take advantage of aren't going to affect you at all. Public charge only looks at before you became a lawful permanent resident, were you likely to become a public charge in the future? Okay, and then I see the clarifying question down there. So if you are an immigrant and you receive Medi-Cal as the partner of your wife, so Medi-Cal is kind of crazy too, because you can automatically be enrolled if you qualify for it. And so if you qualify for it and you're as part of the same household, because it has no effect on your immigration status, I wouldn't worry about Medi-Cal at all. The California government has made they've put in a lot of different protections in there to make sure that if you were somebody that couldn't be covered by the federal government, that the California government covers you. But any lawful permanent resident qualifies for Medicaid or Medi-Cal if they meet the income thresholds. I know that was a lot of questions, and so I'm going to give everybody a couple minutes to answer, put in any additional questions if I didn't answer something clearly. Okay. Well, I think that is it. If any of you have any questions, you can always feel free to email us. You have our contact information on the screen. We are a small but mighty team, so you know that when you reach out, you're going to be talking to myself, Andrea, or our colleague Hector. So you're in good hands. So feel free to reach out to us with any questions or concerns you might have. And thank you so much for joining us tonight.